Hello, everyone, and welcome to Uncivil Law. For today's case, we have some cops who were fired because they reported some things that concerned them, and they are complaining that they were retaliated against. So, this is the case of Penny Nicholas Korn versus the Mississippi Department of Public Safety. In this case, we're going to learn a little bit about retaliation claim and learn what happens when the thin blue line breaks. So, let's get started with this. This is a First Amendment retaliation claim stemming from the termination of two state employees for allegedly reporting an internal investigation into patrol issues issuing non-existent traffic violations. Okay? The plaintiffs were employees with the Mississippi Office of Highway Safety. Korn, that's the guy's name, Korn initially served as the office's director. Korn, which is the person's name, initially served as the office director, but thereafter Mississippi's then governor, Phil Bryant, named her as the governor's representative of the Mississippi Office of Highway Safety. Jennings was a division director. At all relevant times, Jennings acted as Korn's assistant, and the two collaborated in evaluating state troops' false claims on how to report the claims to the National Highway Traffic Safety Administration. This is the extent of the allegations with regard to their duties and functions as the office's director, governor, representative, and department director. So we got a whole bunch of things, right? We got a bunch of people being hired, to perform police actions. They're being purported to very high roles. And there are some false claims, they think, being reported to the federal government, which is, incidentally, a no-no, as you should well know. So you can't do that. And so they came to this attention and they want to do something about it. And they tried to do something about it and they were fired. So that's super, super encouraging about Mississippi. Let's read on. In paragraph 10 of the complaint, the plaintiffs allege that they learned from a highway patrolman that the Office of Mississippi Highway Patrol was conducting internal affairs investigation into whether state troopers were writing ghost tickets in order to receive overtime pay under federal grants. Super exciting. So the federal government has some grants. National Highway Traffic Safety Administration, they're concerned about traffic and safety. That's what they're concerned about. And they're offering some grants to some law enforcement. And some of these people are writing tickets that don't exist in order to claim overtime pay, in order to, what would be the word for that? That's right, defraud. Defraud the federal government for, pay that they didn't earn. So this is apparently what was happening. And these people came into knowledge about it. Super wonderful. On October 3rd, 2006, Korn voiced the concerns to the various officials who were named regarding this investigation of these ghost tickets. As a direct and proximate cause of this reporting, the federal government allegedly ceased all grant funding, which prompted notification of the governor. So they learned about an internal investigation that was occurring into whether or not some people were writing some ghost tickets. That's what they learned about. And they reported it to the federal government and said, hey, we're directors of this various thing, and we've learned that some of these departments are conducting an internal investigation as to this. And we just want to let you know that this is a thing that might exist. And the federal government took a look at it and said, oh, you've defrauded the federal government. You're not allowed to do that. So as a result of this, we're not going to give you any more money for this program because you defrauded us, which, is the kind of thing that you as a person probably would do. If you're giving someone money for something, and it turns out they're not doing that something, you'd probably be disinclined to giving them further money. But you came in between a cop and their money. So that's what happened. Korn continued to discuss the investigations with Jennings, and both of them allegedly stayed in contact with the federal government and remained subject to subpoena to testify about these matters, as you might expect. Yeah. So, the federal government might subpoena them. That's right. Okay, but then, in mid-October, Cruz terminated Korn, and the following month also terminated Jennings, because they reported their findings to the federal government and they weren't playing nice within the thin blue line. Super. While the plaintiffs were not given an explanation for their termination, they alleged the termination was a direct and proximate result of their meeting, planning, and notifying the federal government of the falsely claimed overtime made pursuant to the federal tickets. So yeah, they're arguing retaliation for whistleblowing, which is a no-no, incidentally. So yeah, you can't do that. You cannot terminate someone for whistleblowing. So Were they terminated for whistleblowing? And is this court going to do anything about it? Let's find out. In October 2017, the plaintiff initiated this action against the defendants. They alleged violations of the First Amendment rights via retaliation and also 1983. They also assert claims under the Mississippi Tort Claims Act for wrongful discharge. Pursuant to the 11th Amendment, a state's sovereign immunity in federal court extends to private suits against state agencies, state departments, and other arms of the state. The plaintiffs are suing the Mississippi Department of Public Safety, Fisher in the official capacity, and Cruz in individual and official capacity. Defendants receive arm of the state recognition as they're under control and direction of the state of Mississippi. In other words, plaintiffs' claims are directly against the sovereign. Given plaintiffs' selection of 1983 and the claims are against the sovereign, the 11th Amendment immunizes defendants unless one of the following exceptions applies. The 11th Amendment bars federal suits against the state agency, or state official in capacity unless the state has waived its sovereign immunity or Congress has clearly abrogated it. All right, so first issue, first problem. We're suing state actors, and we're using that word very deliberately in this particular instant, because what we usually mean by state actor is a government actor, but we're using it a little bit more precisely in this circumstance. We mean literally the arm of the state as such. So there is an immunization in the 11th Amendment that bars federal suits against the state government. Not the municipal government, not city governments, but state government specifically. And we're in federal suit. So we're suing the Mississippi Department of Public Safety, which is an arm of the state. So the first problem is we can't sue in federal court unless there's an exception that applies. So is there an exception that applies that allows this case to be heard by the federal government? Let's find out. Beginning with the plaintiff's state claim against the Mississippi Department of Public Safety for injunctive and monetary relief, the state of Mississippi explicitly preserved its sovereign immunity as a federal jurisdiction when it promulgated the statute. So yeah, there are state issues that may or may not apply, which would be heard by state courts. But when they granted the state claim of relief for the state torts, they expressly reserved federal immunity. So you might have a cause of action in the state government. Good luck with that. But you can't sue them in federal court because they have sovereign immunity. Yeah, okay. The plaintiff's state claim, insofar as it seeks damages and an injunction against the Mississippi Department of Public Safety, is therefore barred of sovereign immunity and was therefore dismissed. So yeah, there's a state tort cause of action. You might have a state claim. Go to state court and argue about it. Good luck, with that plan. But unfortunately, the Constitution is clear. You can't sue the state government in federal court unless an exception applies. And the state, when it created this tort cause of action, reserved its immunity. So you might have some cause of action, but not in federal court. As it relates to the Mississippi Department of Public Safety's commissioner defendants sued in their official capacity, the state claim is grounded in declaratory and injunctive relief. However, state officials cannot be sued for violation of state law in federal court because of the immunity we just talked about. No, you can't get declaratory relief here because they're immune. Try state court. Let us know how it works out. The plaintiffs can also not hold Cruz personally liable for actions or omissions occurred within the scope of official duties because, again, state-level action, 11th Amendment immunity. Yeah. Sovereign immunity prohibits the plaintiffs from seeking injunctive relief against the Mississippi Department of Public Safety under the retaliation claim. The Mississippi Department of Public Safety has specifically not waived its immunity from suit in federal case, and court has not expressly waived sovereign immunity for 1983 suits. So yes, you might have a retaliation claim. You might have a First Amendment retaliation claim. Unfortunately, it exists as a matter of state law. You were state employees, and what was taken away from you was a state agency position. So yes, you might have a retaliation claim. Unfortunately for you, all those causes of actions that exist are state-level action. So yes, you might have a retaliation claim, but not in federal court. The 1983 cause of action does not expressly waive sovereign immunity. It has some limitations. It has some ability, but it doesn't eliminate all the sovereign immunity, and not here. So to the extent you have a whistleblower complaint for a state level cause of action, go to a state court. Let us know how it turns out. That should be fun. The plaintiffs seek declaratory judgment that Fisher and Cruz violated the First Amendment. This prayer for relief is fundamentally retrospective because it does not relate to an ongoing violation of the federal rights. So there might be a difference if it's ongoing deprivation. That might trigger a 1983 problem unto itself, right? So if it was ongoing, that might be a problem, but it's not. It happened in the past. It's a discrete event that occurred in the past. It's not ongoing. You did something, you were fired. It's a discrete event at a discrete time. It is not an ongoing problem. So that's different, right? So therefore, the ex parte Young doctrine, which is a case that deals with when you can do sovereign immunity and not, the ex parte Young doctrine does not permit declaratory judgment that respondent violated federal law in the past, as we have here. If it were ongoing, you might have an issue. But it's in the past. It happened in a discrete point in time. So therefore, what remains under this federal claim is the injunctive relief against the official capacity and Cruz as the individual and a monetary relief. So let's read on. Now reviewing the First Amendment action, we determine whether the plaintiffs are entitled to First Amendment protection. The district court determined plaintiffs failed to plead a plausible claim because the statements were not protected as alleged speech was not outside their ordinary job duties. I love this so much because it is so technically right and so very, very wrong. But this is legally correct analysis, and it's beautiful in its way. It's hard not to admire it, in its legal precision. The plaintiffs maintain that their communications were made as citizens rather than employees, thus outside their job duties and warrant First Amendment protection. We agree with the district court that no, not so much. I love this so very, very much because it's so technically correct. The First Amendment protects your right to speak as a private individual as it relates to government action. So the government can't prevent you from speaking as an individual or retaliate against you or discriminate against you or come after you in any way for your private speech. But that begs the question, is this private speech? And the answer is very technically and very correctly, no, it's not. Because remember, they were reporting this because they were government employees. They knew about the internal investigation because they're government employees. They came into that knowledge, and they were reporting it because of their government role. So it was government speech, not personal speech. It was the speech of the Mississippi government. And Mississippi, for better or worse, is in control of its own speech. Therefore, when they reported to the federal government, they didn't have the right because they were speaking as though they were Mississippi, but Mississippi didn't want them to speak this way. So they couldn't speak because they weren't exercising private speech, but public speech. It's not wrong. It's very technically legally correct. And I just like to see the mechanisms of it work because it's such a catch-22, right? They only knew about it because they're public employees. They wanted to alert the federal government because they're public employees. But because they're public employees, they can't because their public employer doesn't want them to. Ta-da! Therefore, it's not a First Amendment violation because the state of Mississippi was only infringing its own speech, which it has the right to do. You gotta love it, man. Our First Amendment guides the First Amendment analysis, whether the employee spoke as a citizen or pursuant to official duties. The plaintiffs were not speaking as citizens when they allegedly reported the ghost ticketing to the federal government. In Corn's capacity as the office director and as the governor's representative, and as Jennings' capacity as the division director, their amended complaint specifically alleges that the two collaborated in evaluating state troopers' false claims and how to report it. Said differently, in the course of pursuing their official employment, they reported in the context of the false claims. They are government speakers. There is no meaningful distinction between the plaintiffs and the federal government's communication about the ghost tickets investigation versus their ordinary communications with regard to false claims. Arguably, by virtue of their employment only, the plaintiffs learned of this investigation because of their speech. That is, the speech may have resulted from specific knowledge they gained as employees. You only knew about it to rat on us because you're employees, and you can't use that against us. It's so wonderful. Given the close relationship between the allegation of the job duties in evaluating false claims and this ghost ticketing reporting, we conclude the alleged speech fell within the scope of their duties and they have failed to plead otherwise. Yeah, so you don't have a First Amendment retaliation claim because you don't have a First Amendment, because it wasn't your speech. It was the government's speech, and they have the right to constrain their speech. That's, it's legally correct. It's bizarro world, but it's legally correct. It's beautiful. It's beautiful. It's beautiful like a snowflake in its construction. It's a beautiful thing to behold. Because the plaintiffs allege the speech first occurred up through the Mississippi Department of Public Safety and the government's hierarchy in their employment capacity, their similar external speech that trails it is also unprotected. So the speech they made through the chain of command was official speech, and this external speech, which is parallel, is also official speech. Yeah. We therefore conclude the plaintiff failed to demonstrate their speech was protected under the First Amendment, because it wasn't their speech. It was Mississippi's speech. And Mississippi would very much prefer that you not rat them out to the federal government. Yeah. Given this holding, it necessarily follows the district court correctly dismissed the claims for 1983 for violation of First Amendment for failure to state sufficient facts. Accordingly, we affirm the dismissal as it pertains to this. For these reasons, we affirm the district court's dismissal, and the suit is barred under the 11th Amendment. So that is our end of the coverage of the case of Penny Nicholas Korn and Twyla Jennings versus the Mississippi Department of Public Safety. In this case, we learned that two government officials who were appointed to high office within the Mississippi Department of Public Safety learned of false tickets that were being created to fraudulently deprive the federal government of money. They decided to tell the federal government about it. The federal government stopped giving them state money, and the state government is unhappy. So they have fired these employees. These employees say, hey, you can't do that. Retaliation and First Amendment. And the federal government, in analyzing this, says two things. First of all, your retaliation claims only exist as a matter of state law. We can't hear them because sovereign immunity, because of the 11th Amendment. We don't have jurisdiction. Yeah. And as to your First Amendment complaint, you don't have a First Amendment interest because it wasn't your speech. It was the government's speech. You were government actors, government employees. It was the government speech. You were acting in official capacity. It's the government speech. And therefore, the government has the right to control its speech. And you ratted out the Mississippi state government, and they would really prefer that you not do that. So they have the right to fire you because you weren't exercising First Amendment rights. It's technically correct. And that's why it's such a great case. But it's okay. It's okay. You still have some state causes of action. So you can still go into state court and argue your state tort claims in state court. So, let us know how that turns out, I guess. And that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.